Thank you very much. And now I call Professor Bogdan IANCU to tell us something about the balanced budget rule and the transversality of agencies.
Thank you. Now, speaking about the transversality of agencies, the discussion will be even more intricate than that about horizontal separation of powers and the federal division of powers. Why? Because the role and place of transversal agencies, of autonomous agencies in the constitutional state is much more contested. There is a phenomenon of autonomy and agentification recently, but exactly the place which these autonomous agencies should occupy in the constitutional state was contested even in the jurisdiction of origin, the United States, from the very beginning. By independent, the doctrine, the commentaries understood the decision of the American Supreme Court, the Federal Trade Commission versus Humphrey's Executor versus Federal Trade Commission. The independence resided in the fact that the president could not dismiss the chairman of the Federal Trade Commission unless he had a cause. However, when the question came, what should be the attributions, the exact competences of this commission, of the generally of the New Deal commissions and of the commissions created in the 70s, like the Environmental Protection Agency, the question became much more difficult, and for a very long time, American constitutional and administrative law played upon taxonomies, meaning it called their attributions quasi-legislative, quasi-judicial, quasi-executive, so that they wouldn't fall in any of the classical branches of power. And of course, this play upon words was labeled by the Supreme Court itself, by Justice Jackson, FTC versus Rubberoid Company, as equivalent to using counterpane to mask an unmade bed, meaning it's very hard. Meaning it's very hard to decide what kind of attributions such institutions should exercise, provided they are situated outside the classical triad of powers, so that they wouldn't interfere with the functions of the classical branches of government. Now, this uneasiness is actually reflected in the terms used in constitutions. In the Romanian constitution, we call them autonomous administrative authorities. In the Hungarian constitution, autonomous regulatory authorities, from which one could deduce that you can only create autonomous independent regulatory commissions. The French call them, after the American denomination, autorités administratives indépendantes, but how independent they are can be seen from decisions of the Conseil d'État and Conseil Constitutionnel cutting down on their attributions and their effective autonomy. The Germans call them unabhängige Regulierungsbehörden. Now, and probably the most similar German institution would be the Bundeskartellamt, which is not formally autonomous. It is subordinate formally to the Ministry of the Economy. So now there is a much uneasiness as to exactly what kind of attributions these institutions can exercise and what exactly does their autonomy reside. If we look at the fiscal compact, it seems to call for such an autonomy to enforce the provisions in Article 3, Paragraph 1. It says that the states should guarantee the role and independence of institutions applying the correction mechanism. However, the next line tells us that this should not impinge upon the full autonomy, the full prerogatives of national parliaments, which is a contradiction in terms similar to that, to the question whether a provision can be of permanent character and binding force and yet be constitutional or otherwise. So there is a problem of contradiction here. The only country of the European Union which created such a commission was Hungary. Hungary actually uses a correction mechanism that is more draconian than that asked for in the fiscal pact. Namely, according to Article 36 of the new fundamental law of Hungary of 2011, the parliament cannot incur a budget deficit until the public debt of the country would be less than 50% of the GDP. The Constitution creates a budget council, which is composed of the President of the National Bank, of the President of the State Audit Office, and its own President, the President of the Budget Council. So there are three individuals who should clear the budget law and also supervise the execution of the budget every 6 months. Now, so theoretically, hypothetically, if they wouldn't clear the budget, this could lead the president to dissolving the parliament. So they have tremendous power which so far they haven't exercised, but left rather the European Commission to deal with the supervision of the budget deficit in Hungary. However, the entrenchment of this institution in the Constitution raises great problems for the future. You have two members that are appointed for 6-year fixed terms, one member that is appointed for the head of the National the Audit Office that is appointed for a 12-year term, and this could lead in a different political configuration, not now because the government in power has two-thirds in parliament, which allows them to appoint or reappoint the head of any institution to change the constitution at their will. But should this political configuration change, the budget council could in fact put tremendous pressure on the political system, and this could lead to dissolving the parliament, and by implication in terms of nominations of the government in office now, it could lead to political nominations of the head of the National Bank, of the State Audit Office head, so that you can control a different majority in parliament after the election. It hasn't happened yet, but it is possible, and this institution is entrenched in the Constitution. The organic legislation of these three institutions, separate institutions, has to be passed by 2/3 of the members of parliament present by means of a cardinal act, which is somewhat similar to French or Spanish organic law. Now, so this would be one implication of a balanced budget rule, creating independent institutions which should politicize something that paradoxically is supposed to be an apolitical exercise, an apolitical monitoring. Now, there is also an impact of the golden rule of balanced budget provisions on existing autonomous institutions. It's very hard to assess what that impact would be because such institutions are of a very variegated sort. You have regulatory commissions with one kind of status, one kind of attributions. You have human rights or non-discrimination autonomous agencies with different attributions. Some of these institutions receive their funds from the state budget, but some of them, especially the utility regulations, like the Romanian utility regulation, charge fees for services rendered to the public. So they are basically self-funded. Reduction of the state budget would not implicate them at all. However, there will be a differential and asymmetrical impact on certain agencies. The balanced budget rule in the fiscal compact is a part of a more general discourse that is fused at the hip with other discourses. For example, the anti-corruption discourse. In the European Union in 2004, the states that joined were compelled by the Commission as a part of the political acquis to be members, to join conventions to which older member states, anti-corruption conventions to which older member states were not parties to. The two countries that joined in 2007 have a cooperation and verification mechanism that targets anti-corruption, and in the case of Bulgaria, organized crime. And the implication is that anti-corruption policies should be pursued through the means of autonomous prosecutors' offices, autonomous integrity agencies. More than that, what had been initially a part of the political acquis, one doesn't know exactly how, became a part of the formal acquis of the Union. So anti-corruption policies were, in the case of newer member states, parts of the Copenhagen criteria, and then they migrated, as more and more new member states joined anti-corruption conventions, they migrated to Chapter 23, Judicial Independence and Fundamental Rights. It includes anti-corruption policies, so now it's a part of the Justice and Home Affairs formal acquis of the European Union. In 2011, and these institutions are perceived as reducing budget deficit, are perceived as helping the economy. Again, the figures that the European Commission comes to are tentative at best. In 2011, they made an estimate based on an estimate of international NGOs, Transparency International, Clean Business is Good Business, and others, and came to the conclusion that 5% of the GDP of the entire European Union is lost to corruption. Now, if you read newer reports of the Commission to the Council and Parliament, for example, the one in 2014, you will see that they already calculated what 5% would mean. It's 120 billion euros. So the Commission states, as a fact, it is unacceptable that 120 billion euros should be lost to corruption, and they cite the report from 2011, which cited Transparency International and Clean Business is Good Business. Now, so what was an estimate of a guess has become a fact and is presented as such in newer reports. And of course, this has an impact on certain kinds of autonomous agencies. In Romania, for example, we have a National Integrity Authority, a National Prosecution Authority that is formally subordinated to the General Prosecutor's Office, but in fact fully autonomous by way of symmetrical means, symmetrical terms of office. So these kind of institutions, one assumes, at least for the newer member states and the member states that are now in the process of accession, will not be affected in any way by balanced budget rules, because the general discourse is that the existence of such institution contributes to balanced budgets. Thank you.
Thank you. Thank you very much for this very interesting presentation, raising beyond our usual discussions at least two interesting topics. One is to what extent one can use or abuse constitution making in order to put into the constitution or constitutional laws regulations which by its their substance belong to original legislation, just blocking future generations from using a regular legislative procedure to amend it. And I think the Hungarian example is extremely instructive, unfortunately extremely instructive in this respect. And another is something which we can call a creative accounting. Of course, if we need to have a GDP calculation increased, we can add some income from prostitution, human trafficking, etc. And then suddenly we can find not only that our GDP is higher, but we also can find that we have more room for a deficit. But this is another problem. Now, what we are going to have in the conclusion of